This petition is dismissed. However, the petitioner would have to be paid his salary for services rendered by. Delivery of order item 23. Dismissed. Item 24. Dismissed. Item
24.
It has been passed over forever from this court.
I feel the the petition for petition for withdrawal tomorrow. You have to check. For withdrawal. Hello. I prepare listing of a WPC matter similar to the item number 10 and 11 totally. Regarding my
Item
similar to my item number 10 and 11 totally. But this matter not listed. I pay for tomorrow.
okay, tender.
Yes, sir. Tomorrow. Hello. I identify the item number 13 of today. The concept of the data set after the
After?
after the concept is
Right. The party, counsel for the party submit that the matter may be listed after the Bihu vacation. These as pleadings are complete. Correct? As pleadings are complete, list the matter after the Bihu. 30.
I pray for listing of this matter for orders after vacation, my lord. Last listed on 25th October.
Go to the registry.
I have approached the registry twice, my lord. Even then, the matter has not.
I don't think so. They've got a list.
No,
They've got a registry.
I approached on
It will come in time, Mr. Counsel.
4th of March and again in April I have approached. Even then, the matter has not.
It will come. It will come on its turn. Heard Mr. C. Purkasa, Learned Counsel for the petition, to submit that in terms of the order dated 27 to 25 March in WBC 3929 of 2024, the respondent were to what?
Allow the petitioner to hold the charge.
Were to give charge of the post of headmaster of the high school to the petitioner, which has not been, some of it has not been. If you notice, returnable in 4 weeks, petitioner takes steps. Within 3 days, this is the matter of
Lordship, 5 your lordship, I can to your lordship, you should notice your lordship. Now, Chopper 3 and 4 and 5, your lordship are concerned. These are related to your lordship graduate science teacher.
That's what they're different.
Different. It may be T-tech, your lordship.
Why is it tagged together?
Because on part this, your lordship, the
You have someone has said, I think.
lordship.
You had,
I was not there, but my colleague was.
so who is appearing in item 2?
Item 2, probably one case has already been disposed of out of the provision.
Item 2, madam, can it be disposed of?
Your Lordship, item 2 pertaining to that, Your Lordship, we have not filed any affidavit.
Here, is it similar to the 3820?
No, your lord.
Different.
No.
Okay, it's not with regard to counting the past service.
No, your lord, that's not the.
Okay. So this has to be, anyway, this has to be separated anyway.
We'll be filing our affidavit separate each case.
Okay, and the 3820 also can go back there.
Lord.
Right. Right. Heard Mr. S. Botthap, Learned Counsel for the petition, and Ms. P. Das. Right. To stop Ms. P. Das, Learned Counsel for the Secondary Education Department is granted 4 weeks time to file affidavit in opposition. That's an item 2. Registry to detach this case from WPC 3820-2024 and WPC 2890-2020. This is the matter of the code. Then in the item 345, what is to be done?
Item 3, this was a matter where
All pay parity.
pay parity. The government has now, on the basis of the 7th pay commission, recommended a scale for us, which is not what we are asking, but then still a revision is. So to that extent, my the affidavit of the finance was picked up. That was the last one.
Okay, in item 3, 4, and 5, you say, Mr. H. Taliha, that is counsel for the finance department, submits that he will be filing affidavit within 2 weeks, 3 weeks, within 2 weeks. Leave the matter up to.
Keep you.
May I please, your lordship, at this stage, I pay for extent of notice.
Yes, you are still under suspension.
Lordship,
Has charge sheet been filed or submitted?
not yet, lordship.
Nothing. Charge sheet or memorandum of charge, nothing. There is no criminal case, correct?
No criminal case, Lord.
So only basically filing of this thing, the filing of the memorandum of charge, whether they have submitted or not. Yes,
Here I am bidding for only SSA. That's not the number.
who is appearing for the higher education? Mr. Kisti.
Yes,
His case is that Ajay Kumar Chaudhary, correct? And you want subsistence allowance also.
Lordship, that is not paid. Lord.
So you pay subsistence allowance in the meantime.
Yeah.
Right. All right, Mr.
Awesome.
R. Sharma, learned counsel for the petitioner, would submit that the petitioner was suspended with effect from 27/12/2024. No. 27/12/2024. Acha, the already show cause notice has been issued
Yes,
to you.
and this is regarding sexual harassment of a girl. Lordship,
So
it notice was issued. I have
Replied.
replied also, Lordship. It was turned down, and subsequently by order dated 27/12/24, they have been suspended.
Correct.
And Lordship, thereafter, appeal was preferred, Lordship. Next, please. Case 42.
So what has happened to the appeal?
Lordship, nothing is communicated to me, Lordship. Let me take instruction in this, Lordship, regarding this appeal.
Oh,
Here it
this
is no-
appeal was issued 2/1/25.
But this appeal has no receipt, nothing, only these pages are here. But it was actually served. That's all.
Or we dispose of the writ petition with a direction to you to dispose of the appeal
Yes,
and also to pay him subsistence allowance in the mean.
Lordship.
That can be done.
Lord.
Or with you, and that can be done. The contempt petition. This appeal can be also submitted afresh
That's fair. That's happen.
if not decided earlier.
Lordship.
Correct. Right. Right, Mr. Principal. Counsel for the petitioner. To submit that the petitioner was appointed as an assistant teacher at Turjia Bora Girls High School, Morrigaon on 1/6/2001. And then rationalized at Dolai Chuba High School by an order dated 7/8/2020. He was then allowed to hold the charge of headmaster with effect from 1/9/2020. Where is the show cause notice? Next para. The petitioner's counsel submit that the petitioner was thereafter issued a show cause notice dated 23/12.
Page 23.
23, Lord. The show cause notice dated 23/12/2024. Under Rule 9 of the Assam Service bracket Discipline and Appeal bracket close Rules 1964. as to why any of the penalties prescribed in Rule 7 of the 1964 rule should not be inflicted upon the petitioner. Hereinafter, in the top part, hereinafter referred to as the 90. The charges framed against the petitioner, to which he has been asked to submit his reply, is as follows. At page 20. Next part. The petitioner submitted his reply to the show cause notice on 27/12/2024 by denying all the allegations, all the charges framed against. Next part. The what is this? They are doing it at an inquiry report. Thereafter, the Inspector of Schools Morilon issued the impugned order dated 27/12/2023, suspending the petition by suspend the petition and holding that he was entitled to get subsistence allowance during the said period. The petitioner's counsel, the petitioner's counsel that the petitioner submitted an appeal dated 2/1/2025 to the Secretary to the Government of the State against the impugned order dated 27/12/2024 passed by the Inspector of Schools Morilon. Saying that the impugned order should be set up and the petitioner should be allowed to rejoin his. Next part, the petitioner's counsel submits that the petitioner has that the petitioner's appeal has not been decided till date, and neither has any subsistence allowance been given to the petition. Next part, Mr. SMP learned counsel for the higher education department,
No, secondary education law.
secondary education department.
Yes, that's one number 313.
Our point number 1 is
3 and 4.
1, 3, and 4.
Yeah.
Submits that there is nothing to show in the appeal dated 2/1/2025, which has been annexed to the writ petition, that the same has been submitted to the respondent number 1. He however submits that if a fresh appeal is submitted by the petition, if the said appeal is again submitted by the petition, the same would be decided by the respondent number. Next, who else? Anybody else is here?
SSA is and
Let me say, okay, Mr.
It's already put.
government is also given.
Mr. B. Chaudhary appears for point number 2. Who else is here?
PC, hey,
Mr. P. Saikya. For point number
5.
5. 6 is RM Barwa.
Yes.
With RM Barwa appears for point number 2. Next part. On considering the fact that the petitioner's appeal has not been decided by the respondent number 1, and keeping in view the fact that there is nothing to show, there is nothing to prove that the appeal which has been, the appeal submitted by the petitioner, allegedly submitted by the petitioner, had been given to the respondent number one. This court is of the view that the petition can be disposed of at the motion stage itself. So accordingly, this court directs the secretary to the government of Assam, secondary education
I
department.
know in this case, appeal to be filed for a director. Director is the appointing of a secretary, is not the appointing of a doctor. It should be
Oh.
proportional to inspector of school. It should go along.
Okay. Then you're right, in Mr. SMPTC. Mr. SMPTC further submit that as the director is the appellate authority, as is the appointing authority
Appoint.
of the petition, the appeal should have been filed to the director of secondary education department. Okay. Yes, any problem?
No, then he will have to file a new.
Correct. In view of the, whatever I said. No, before that. And keeping in view, the fact that the director is the director of secondary education is the appointing authority. This writ petition is disposed of with liberty being given to the petitioner to file an appeal against the order dated 27/3/2024 passed by the inspector of schools Moringa to the director of secondary education. The same should be filed within a period of
2 weeks long.
2 weeks from today.
Lot.
The director of secondary education shall thereafter take a decision on the petitioner's appeal within a period of 4 weeks from the date of receipt of the petitioner's appeal, which shall be accompanied with a copy of this order, along with a copy of this order. Okay. In the meantime, the respondent shall ensure that the subsistence allowance payable to the petitioner is paid.
Yes, if not paid, because it is the first motion says it should be
Actually,
disposing of.
if not,
To the item to be
actually,
inspected.
what have I said? That can ensure that it can ensure that the petitioner is paid his subsistence allowance from the date of his suspension, if not paid earlier. The writ petition according to the code.
And one more data, the petitioner will submit a copy to writ petition along with the check back. Because it is a
Okay, you
motion
say,
for the doc-
you say, copy from the date of receipt of a copy of the appeal, along copy of the writ petition, along with a copy of the order.
apply.
Yes,
Here, my lord, I have challenged the, my lord, appointment of the respondent number 5. Sir. Pursuant to an advertisement in the petitioner and others, my lord, have,
why you say that you should be given 4 marks instead of 3.
Lord.
Why?
my lord, kindly see, my lord, the advertisement is at, page 30, my,
Page 30 is advertisement.
page 30 is the advertisement, my lord. And
What does
the
it say?
relevant portion is at page 33, my,
33.
page 33. my.
Okay.
First point, my lord, leadership skill format. Result of SSLC AHM examination in case of graduate teacher and HS final examination in case of postgraduate teacher. Here, my lord, I am the postgraduate teacher.
Where? Page 33, which one?
Page 33, my lord, first, my lord. Sheet number 1, leadership skill format.
Yes.
Result of SSLC AHM examination in case of graduate teacher and SS final examination in case of postgraduate teacher. In my case, my lord, postgraduate teacher, since I am postgraduate teacher. In the
So you have got 80%, above 80%.
4 marks, my lord. Now, kindly see, my lord,
How much percentage did you get?
page 29, kindly see.
Page 29.
Page 20. HM, my lord. Higher secondary.
87.59.
Page 29. Here, my lord, this is the result of my lord proceeding here, my lord. Higher secondary result 2024, and my school, my lord, total percentage 87.59. So I attended
It
for
should have been here before. Then what was the compare? So there is one post of principal.
Lord.
And how much did the other person get, the respondent?
she was her marks, my lord, page 56, my lord. Page 56, page 56, column number 9, my lord. She was granted 4, my lord. Page 56, jail number 8, column number 4.
56,
Sorry, my 60, my lord. Page 60.
page 60, column number.
Serial number 8, column number 4, column number 9.
You got 4.
She was awarded 4, my lord.
Okay.
In my case, my lord, page 61, my lord.
You are.
Page 61, serial number 16, column number 9, my lord. I was awarded 3.
So what was her total marks?
Her total marks, my lord,
15.
15
And your total marks is 15.
14.
14.
My
So if you get one mark extra, then you will both be 15.
Okay.
Then how will they select according to age?
Another round is there, my lord, to hold the post of principal, my lord. The candidate must have, my lord, must possess, my lord, master's degree, my lord.
Master degree.
Master degree.
Where does it say that?
Graduate teacher, my lord, but she pursued her master degree during her service, my lord.
Maybe. But
Lord-
prior to her appointment as principal,
She has master degree, my lord, but during her service, my lord, to pursue educational course, my lord, prior permission from concerned authority is required, my lord. As per my lord, Assam Civil Service.
so they must have given prior permission.
Lordship, so far my instruction, my lord, that from
No, that is a different issue.
Lordship.
That is a different issue. That is a different issue.
So, my lord, at this
So
stage,
she has got no. The thing is that, okay, supposing you. My question is, okay, supposing we give you that 1 mark,
Lordship,
then you are at par. Now, who will get the post? Age. Will it be age?
then as per
Seniority. Who is
senior,
you are senior?
and-
Okay, you are senior
and
in the school. Same school.
same school. She from another school, my lord, but
But you are senior as a teacher.
as a
And who is age-wise? Age-wise?
age-wise and senior, my lord.
Age-wise, you are senior. And seniority also, you are senior.
Earlier also, my lord, in the same school, my lord, I was my
Okay, right. I heard Mr.
K. Barua.
K. Barwa, learned counsel for the petition, who submits that in the selection process for the post of principal, the petitioner was not given 4 marks for the was not given 4 marks in respect of her percentage of marks that had been secured. See,
33.
marks, no, that is your mark secured in the higher secondary examination. Wherein wherein it was 87 point, it was recorded as 87.59%. The petitioner's counsel submits that in terms of the conditions laid down by the respondents in their advertisement dated 2/9/2024 for filling up the post of principal from among postgraduate teachers, comma, persons who secured about 80 marks was to be given 4 marks. While 71 to 80% were to be given 3 marks. As the petitioner was given only 3 marks instead of 4 marks, the petitioner's total score, total marks, was only 40, as against the selected candidate, that is the respondent number 5, who had secured 15. The petitioner's counsel, the petitioner's counsel that if the petitioner was given the extra, if they was given 1 more mark, as he was entitled to the same comma, his marks would have been at par with the marks of the respondent number 4. It submits that the petitioner is senior to the respondent number 4.
Respondent number 5.
Respondent number 5. Respondent number 5. How many private respondents are there?
Only 1 mile.
Respondent number 5. Besides being older in age than the respondent number 5.
As well as date of training.
So he further submits that the date of joining is a school teacher was earlier in point of time than the respondent number 5. Accordingly, the petitioner should have been selected for the post of principal instead of the respondent number 5. Issue notice, returnable in 4 weeks. Who accepts notice? Mr. U. Sharma accepts notice on behalf of respondents number 1 to 4.
1, 2,
4.
3.
Please go to land.
3, 4.
Please, huh? 1 and 2.
No, my lord.
1 and 2.
I am only 2, my lord.
1 and
Here,
2.
my lord. Here, my lord. Whatever, my lord, in the courses, it is shown as higher education. But, and copy also probably not up to us. It is higher education.
Anyway, it's okay. It's okay. It give you.
Courses may be reflected in secondary education.
Okay, okay. So you are appearing for 1 and 2.
Yes, my lord. 1 and 2.
1 and 2. Who is for BTC? BTC. Mr. Upamanyu. Is he for huh? RB Bora? Miss RB Bora accepts notice on behalf of respondent number 3 and 4. Petitioner will take steps for service of notice upon the respondent number 5 by registered post with AD within 2 days. Within 2 days. Leave the matter after 4 weeks.
May I beg for a date, my lord?
Give a date. Oh, Mr. B. Chowdhury appears for the respondents number 3 and 4. BTC.
In courses, our.
Okay, registry to reflect SC secondary education instead of higher education.
Yes.
In the college.
Maybe. Pursuant to my lord, your direction in the science institute teachers statement, the department has initiated the process of promotion to the post of headmaster in high school.
Where is the direction?
Direction, my lord, your lordship, page 3. There's a common order repassed by your lordship pursuant to the amendment made in the service.
Okay, ha.
And
yeah.
thereafter the process has been initiated. And page number 70 and excerpt 13.
70.
70. Now this letter, my lord, inspector has asked for particulars of the concerned teachers who are interested for applying, my lord. And is asked. And as per the rule, my lord, SCR for 3 years is required to be submitted. In respect of the petitioner, in the next page, you will find in the while submitting the, my lord, it is cancelled by the IS, my lord. SCR of the petitioner has been cancelled without any
Cancel for this,
Cancel. just he has cut it and my lord signed cancelled. Remark cancelled and signature. IS. That
Yeah.
will be done, my lord.
How can it be
I
cancelled?
have to take inspection here, my lord. After that, my lord.
Naturally.
In the meantime, my lord, if the process is proceeded further, all the petitioners, all other candidates has been forwarded except me, my lord. So, my lord, it may be protected for.
My lord, it has also been.
But this post is for headmaster's post.
Yes, yes.
But for which post, which headmaster, which school?
It is not
That
a-
we, there's
it is
nothing there.
district
Then
wide.
how do we do?
That is, one post at least should not be filled up, my lord. Otherwise, it is
For which district?
for Borpeta district. Because I am the senior most teacher in the entire district.
No, what they can do is they can make the selection, but let them not declare the result.
Yes.
For the time. One post, why should it be reserved for you? Or maybe one post can be reserved.
One post can be reserved, my lord.
Okay, right. Third, Mr. B. Purkasa, learned counsel for the petitioner, who submits that during the verification of documents of the graduate teachers for promotions to the post of headmaster of provincialized high schools under the BDC, Barpita, the petitioner had submitted all his documents for being considered for promotion to the post of headmaster. However, while all the other while the documents of all the other candidates have been sent to the directorate of what secondary education for consideration, the petitioner's application has not been sent due to the petitioner's annual confidential report bracket ACR for the year 1/4/24 to 31/3/25 having been cancelled by the
Yes, my lord.
inspector of school. Which inspector of school?
Borpeta, my lord.
Barpita. Without giving any reason for the same and without giving any opportunity of hearing to the petition. Issue notice returnable in 3 weeks. 3 weeks. Mr. U. Sharma accepts notice on behalf of
Respondent number one to.
Huh?
150, my lord. All the response.
1 to 3. All the response. Mr. U. Sharma shall obtain instructions as to why the petitioner's ACR has been cancelled by the inspector of schools by the next day. List the matter on, give a date. Put that. 3 weeks. But that will take time. I don't think it will.
It will take time.
We'll consider your interim order on the next day.
Yes.
Will there be appointment? Done?
Yeah, it's my lord.
Done.
So yes,
Okay, right. Yes. Till the next day, the respondents are directed not to fill up one post of headmaster in the district, in the secondary, in the provincialized school, in the
High school.
secondary, in the
in the district of my lord,
no,
Borpeta.
in which school?
High school.
High school?
Yes.
High school. In the provincialized high school. It shall not fill up one post of headmaster in the provincialized high school. Or for the district of Barpeta. In the district of Barpeta.
Sir, I need some time to get instruction. This is the not first time the petitioner has facing this disciplinary action
Okay, not the first, is the habitual.
in my, as per my instruction. I pray that it may be fixed on 24.
Right, Mr. S. Thakur appears for the petitioner and submits that the order dated 25/3/2025, by which the petitioner has been disqualified from further studies, should be satisfied. Miss T. Wapangla appearing on behalf of R. Mazumdar, learned counsel for
University.
the Dibrugarh University. Dibrugarh University, is granted time to obtain instruction. He submits that the petitioner, she submits that this is not the first time that the petitioner has been given such an order, correct?
No, that's it for this one. This is for the first.
Facing, he has been expelled from the hostel.
Oh,
misbehaved
sir,
with
She submits that she submits that the petitioner has been given various punishments on different occasions by the Dibrugarh University. This is the matter on 24.
Obliged. 10, 11, 12, your lordship has earlier issued notice.
Okay, right. Heard Mr. S. Thakur, learned counsel for the petitioner, who submits that the petitioner should be given his promotion from the date of his eligibility with regard to the career advancement scheme. However, the petitioner has been given his promotion from the date of the notification for promotion and not from the date of his eligibility. Issue notice returnable in 4 weeks with the N. Upadhyay. Do permanent excess notice on behalf of
1, 2, and
1, 2, and 3.
3.
Who else is there? Four. Petitioner will take steps within 2 days. Within 2 days. Point number 4.
Lordship, the other connected cases are WPC 1772 of 2000.
This is the matter along with WPC number
1772 of 2000.
1772 of 2025. That's
And
all. That's
one-
enough. That's enough. 11 and 12, same order.
Same. Hello. Okay.
This is item 25. For 25. No one appears for the petition on call. Mr. P. Saiki appears for the. For whom?
And for deputy commissioner.
Therefore, the respondent number 7. And Mr. P.K. Bora appears for elementary education parts. This is the matter after the vacation. Okay. Right. Covered. Covered matter, the same thing. Miss D. Chauhan, appears for the petitioner. Who appears for the respondent?
I am.
Mr. P.K. Bora for?
2, 4, and 6.
2, 4, and 6. While Mr. P. Saikia for?
1, 3, and 5.
1, 3, and 5. We put Mr. P. Saikia for 1, 3. Okay. Then this is dispose of enters of that order. Because out here, of course, 2005, but then not considered by the DL. Correct? Not considered. DLC or SLC?
DLC has considered.
SLC. DLC has recommended, SLC has not considered. Correct? So it's okay, no change.
May I please, Lordship? Lordship, please, let up party to,
Non-provincialization.
what is the cohort item, sir? I have an X. As well as what are the. As well as the suspense of. Issue command.
Is it a covered matter?
So even his petitioner was recommended, so fine. At least 79.
I don't know. I'm asking him.
29 and subsequently with the communication of Department of Finance pay 31. This 31. That is the communication by IS total letter of PhD. This is the list who had dropped because of non-inclusion of
Just a minute. Yeah.
Direction may be given to the respondent authorities, specifically director, to verify the method. If he is found in.
I heard Mr. M. Mohan, Learned Counsel for the petition, and Mr. U. Sharma for the. Mr. U. Sharma for
Respondent number 121.
1, 2, and 3. Who appears for the others?
Authority is headmaster.
Right. The respondent number 4 is the headmaster of the high school. The petitioner has assailed the impugn action of the respondent authority in not provincializing the service of the petitioner on the ground that the name of the petitioner does not appear in the DIS code. Is it? Not. In the UDIS. What is the UDIS? Some UDIS. What is the full form of UDIS? U means for what?
Unified.
Unified. District Information System for Education, bracket UDIS, yeah, of the Subansiri Kai Barta High School, Lakhimpur district. The petitioner's case is that he has joined her service on 9/8/2000, and as per the provisions of the erstwhile Assam Venture Educational, not erstwhile, as per the, cannot say erstwhile, you have to say as per the, what? As per the, erstwhile Assam Venture Educational Institutions, bracket Provincialization of Services, bracket Act 2011, which had been set aside by the court, the services of the employees of the school had been provincialized with effect from 1/1/2013. Although the petitioner was eligible to be provincialized, her service was provincialized, she was arbitrarily left dropped out from provincialization of her service, on the ground of non-inclusion of her name in the UDISC and or the DISC data. Well done. After the coming into force of the Assam Education bracket provincialization of services of teachers and reorganization of education institutions by Act 2017, hereinafter referred to as the 2017 Act. comma. The district scrutiny committee, after due verification of her eligibility, recommended the petitioner for provincialization on date.
That, I think the.
Okay, anyway, okay, full stop. He submits that though the act of 2000, though the 2017 Act does not prescribe any requirement for capturing the names of the teachers of the venture high school in the DIS code for provincialization of their service, comma, the respondent authorities are not acting upon the recommendations of the district scrutiny committee. He submits that the petition causes submit that the present case is covered is a covered case in terms of the decision of this court in the case of nearly that's bad. When you want to sneeze and you can't, no? False alarm. Not exactly false alarm, half alarm. What do I say? Kishore Kumar Nath and others versus Estate of Assam and others reported in 2023 5 GAU LR 54. Huh?
Paragraph 6.
Where is? That's all. Huh? He accordingly submits that the present that the case of the petitioner be sent to be verified by the respondent authority and to take a decision in terms of paragraph 16 and 18 of the judgment of this court in Kishore Kumar Nath Supra. Correct? Mr. U. Sharma, learned counsel for the okay, this is point number 2, not respondent authority. Mr. U. Sharma, learned counsel for the secondary education department, submits that he has got no objection to the prayer made by the petitioner's counsel in view of the fact that this is a covered. I have heard the learned counsel for the part. Section 16 and 18. No, section, wait. Section 15, 16.
Paragraph.
Seventeen and 18 of the writ petition of this is now in the case of Kishore Kumar Nath Supra is reproduced here in video. Next up, a perusal of the same shows that the the respondent authorities cannot insist upon the names of the petitioners who have been rendering service in Venture High School and Venture Higher Secondary School to be captured in the DIS code of 2009-10, which would be contrary, which is contrary to the 2017. Make it till 19. Take it till 19. Parana. In view of no, as such, this court had directed the director of secondary education to consider the case of the petitioner therein for provincialization of their service as teachers and slash or tutors by making necessary verification in terms of section 4 of the 2017 Act, and without insisting upon their names being captured in the DIS code of 2009, 10 or prior thereto. Section 4, Section 4 of the 2017 Act states as follows. On considering that the present case is a covered case and as the covered case and as the case of the petitioner hearing and as the facts of the writ petition hearing is similar to the facts of the case in Kishore Kumar Nath Supra. This court directs the Director of Secondary Education Department to consider the case of the petitioner in terms of consider the case of the petitioner for provincialization after making necessary verification in terms of section 4 of the 2015.
Unless as per provision of 2017.
Okay, as per the provisions of 2007. In terms of the provisions of the 2017. The writ petition, the same will be done within a period of 6 months. Within a period of 6 months from the date of receipt of the certified copy of the report. The writ petition is accordingly disposed. Then in the next case, out here the
Full name is,
school name is
school name is Milot,
I did not mention the school name also. I did not mention.
Patalpara.
I say joined our service, joining us the 22/6/2005.
Patalpara.
No, I did not mention. Should I mention the school name?
Okay.
Okay, mention the school name. Out here in this one, it will be Kathalpara High School, Lakhimpur district. Okay. In the other one, I think I mentioned it. So that's all.
Lot.
What are you challenging?
I am challenging the inquiry report, which is,
How can you challenge an inquiry report?
because the entire inquiry load,
Mr. Counsel, did you submit your reply to the inquiry representation against the inquiry report?
Lordship, that was, I have received, recently, Lordship, so I have already filed today.
You have submitted to the
I have
authorities.
submitted, Lordship, but the entire, if your Lordship gone through the entire inquiry report.
So let them take a decision.
Lordship,
Then it is premature. No case.
because Lordship, the inquiry report is completely against.
Yeah,
That
that's
was
submitted.
completely
Naturally,
against the natural justice, Lordship.
Naturally, it has to be against you.
Lordship,
If it is not against you, then they will close the case.
my lord, your lord, kindly see, Lordship, there are so many judgments, Lordship, that the charge.
Show me the judgment.
And I have prepared a notes, Lordship.
Yes, show me. Where?
the judgment.
Which para?
My lord, your lordship may kindly see the AIR 1988 SC 117 ES Venkat Ramaiah.
Yes.
Okay, that paragraph 4, lord.
Yes.
Paragraph 4 and 9, lordship, are important, lordship. 4. We have
Yes.
given our anxious consideration to the submissions made on behalf of the applicant, and we have further considered the aforesaid authorities referred to by the learned counsel for the applicant, but we do not find any merit on the applicant's submission to justify interference with the High Court judgment. Article 311 Constitution requires that reasonable opportunity of defense must be afforded to a government servant before he is awarded major punishment of dismissal. It further contemplates that disciplinary inquiry must be held in accordance with the rules in a just and fair manner. The procedure at the inquiry must be consistent with the principles of natural justice. Principles of natural justice requires that a copy of the document, if any, relied upon against the party charged should be given to him, and he should be afforded opportunity to cross-examine the witness and to produce his own witnesses in his defense. If findings are recorded against the government servant, placing reliance on a document which may not have been disclosed to him or the copy whereof may not have been supplied to him during the inquiry, when demanded, would contravene the principle of natural justice, rendering the inquiry and consequential order of punishment illegal and void. These principles are well settled by a pattern of decisions of this court. We need not refer to them. However, it is not necessary that each and every document must be supplied to the delinquent of the government servant facing the charges. Instead, only material and relevant documents are necessary to supply to him. If a document, even though mentioned in the memo of charges, is not relevant to the charges, holding the charges proved against the government servant, no exception can be taken to the validity of the proceedings for the order. If the document is not used against the party charged, the ground of violation of principle of natural justice cannot successfully be raised. The violation of the principle of natural justice arises only when a document, copy of which may not have been supplied to the party charged when demanded, is used in recording findings of guilt against him. On a careful consideration of the authorities cited on behalf of the appellant, we find that the obligation to supply the copies of a document is confined only to material and relevant documents, and the inquiry would be vitiated only if the non-supply of material and relevant documents when demanded may have caused prejudice to the delinquent officer. Thereafter, paragraph 9, Lordship. It is now well settled that if copies of relevant and material documents, including the statement of witnesses recorded in the preliminary inquiry or during investigation, are not supplied to the delinquent officer facing the inquiry, and if such documents are relied in holding the charges framed against the officer, the inquiry would be vitiated for the violation of principle of natural justice. Similarly, if the statement of witnesses recorded during the investigation of a criminal case or in the preliminary inquiry is not supplied to the delinquent officer, that would amount to denial of opportunity of effective cross-examination. It is difficult to comprehend exhaustively the facts and circumstances which may lead to violation of principle of natural justice or denial of reasonable opportunity of defense. This question must be determined on the facts and circumstances of each case. While considering this question, it has to be borne in mind that delinquent officer is entitled to have copies of materials and relevant documents only which may include the copy of statement of witnesses recorded during the investigation or preliminary inquiry, or the copy of any other document which may have been relied in support of the charges. If a document has no bearing on the charges, or if it is not relied by the inquiry officer to support the charges, or if such document or material was not necessary for the cross-examination of the witnesses during the inquiry, the officer cannot insist upon the supply of copies of such document, as the absence of copy of such document will not prejudice the delinquent officer. The decision of question whether document is material or not will depend upon the facts and circumstances. So, this is one. This is, Lordship, in this regard. So here, Lordship, if your Lordship gone through the entire inquiry report, that inquiry departmental proceeding should be taken up individually, Lord, not from the influence of the.
Mr. Counsel, show me your letters out here. Where is your reply to the show cause notice? Oh, is it here? No reply. You have not
No,
submitted.
Lordship,
Huh?
because today.
Just a minute. Just a minute. I'm asking him.
Yet he has not submitted his reply against his second proposed notice. Whereas they would.
No, again, the first show cause notice is there any reply?
He replied.
Where is that? I want to see that.
It was done.
No, Mr. Kamal, I want to see that. Please, let us not go beyond my question. Where is your reply to the first show cause
That
notice?
page 34, Lord. That is charge against the charge.
34.
Against first show cause notice.
34. Okay. Now you see, the second show cause notice, according to you, that pertains to the inquiry report. Now, according to you, that the inquiry report has been made on the basis of some documents which are not supplied to you.
Yes,
Correct?
Lord.
So you make in your representation to the inquiry report, you say whatever you're saying now. You cannot say it here.
Yes, Lord. I
You
have
say it there, and then when you see, because an inquiry report is not the final decision. The procedure is when the inquiry report is made, it is furnished to the delinquent officer to enable him to make a representation against the same. Then when you make your representation against the inquiry report, with all your objections on the basis of the inquiry report, like the writ petition and your affidavit in opposition is your representing. He'll take a decision. Now that decision can be challenged. But you see, because in your reply to the first show cause notice, there was no mention made by you that you have not been supplied documents. Everything was hunky-dory, you gave your reply. So the issue now that in the inquiry report it has been done on the basis of some documents which were not brought to your notice. That issue can be decided by the disciplinary authority after you submit a representation on the inquiry report. That's all.
My lord, the entire inquiry was done, lordship, in violation of rule 9, lordship. Your lordship,
Maybe that you write in your thing. This is not the forum. This is not the forum.
moreover,
Why?
lordship,
Look, it's like this. Why? Anyway, on the other side of it, without going into this, you see, why are you trying to do away with one avenue of challenging the final decision that may go against you? By coming to this court, you're closing off one avenue. The disciplinary authority might take a decision in your favor. How do you know it might not, he will not take?
How he can
lordship, moreover, lordship.
It's like this. Supposing a person could go to the tribunal, which decision can be challenged in the High Court. Now you come straight to the High Court, then you have lost one avenue of appeal. One.
My lord, then appellate provision is also there, lordship. Then I have to go to for it.
do that?
Lordship, I may fail, lordship, because lordship, police yet not filed any charge sheet, lord. So there are judgments, lordship. Lordship, there are judgments, lordship.
That is all. There's nothing. Right.
Then lordship, then without interfering, lordship, my final judgment may be taken up, lordship. In the meantime, my
Final judgment?
lordship, final,
No, I'm disposing this off. I cannot keep this pending. This cannot, keeping this pending can have an influence on the disciplinary authority. And supposing the disciplinary authority exonerates you, then nothing doing. You want to withdraw, I'll allow you to withdraw. You want to, otherwise I'm dismissing.
liberty may be granted to challenge.
Mr. Counsel, that is always there. If you are exonerated, will you challenge?
liberty
No, lordship.
Then
If there is any-
if you are held guilty, a new cause of action is there.
well, that inquiry would already make me guilty.
Naturally, but inquiry report is not the final thing. It's like a writ petition. It's like a writ petition. It is your side of the story. Then affidavit in opposition will come. Then the court will decide who is more handsome.
I may be allowed to withdraw it, lordship, with the party. Subsequently,
Okay, right. Mr.
NH forward.
NH Borbuya, Lord Counsel for the petitioner, please that he may be allowed to withdraw the writ petition. Mr. S. Tutia appears for the
1 and 2.
Respondents number 1 and 2.
1 and 2.
The prayer of the petition counsel is allowed. Writ petition is dismissed as before.
Liberty may be.
No, that's already there. I'm not. That cannot be used as a tool by you to somehow influence the disciplinary authority. All right. It is. 14.6. But what is this domestic inquiry? What is this? Read me all this. What is all this? Item? Yes. What is the final instruction?
Some document has not received from the.
Director has not written one letter also till. Who is to take the decision? Not the principal of a school.
No,
Who is he?
principal has to supply the document. Principal has to furnish the document.
No, no, the
Somebody-
issue is, okay, supplying of documents is one thing. The issue is whether you are going to waive the recovery of the excess amount or not.
It is dependent upon my lord, the situation,
Correct. Now, who is going to decide that?
it will decide.
So why is it being stuck between the principal of the college and the inspector of schools?
There my lord, in this letter, the inspector has written that the principal has, from the principal, some document has not received. There my lord, in the second para. Thereafter, a letter received from the DSC Assam regarding the waiving of excess royal amount of SK San Muhammad Ali, retired laboratory bearer, and a reason behind the excess royal of the said incumbent along with the field performer to the DSC Assam. Accordingly, a
Mr.
letter
Counsel,
received to the principal are-
you see, there's no point reading. If you cannot take the documents from the principal, if you cannot control your principal, you're not fit to be inspector of school. You leave your job, let some other officer who can work do the job for you.
So sometime may be granted.
We are always giving you time. The last, you see, where 1, 2, 3, 4, where you 5, yeah, 5. Time has always been given to you. Time has been given to you time and again.
And I will inform the inspector.
You see, you see, as per your letters, you are stuck between between the inspector of schools and the principal. Now, have you read the last order of this court? No. Please read the last order of this court. Look at your website. Look at the last order.
I'm not suspect that the principal has already handed over and he's there.
Not only that, you see the last order. What did the last order say? Now, who is telling the truth? The- you all are not sure who is doing what. And whether Mr. B. Kaushik was telling the truth on the last court date. This order is here. It is here. It is not your case that this order is wrong. Then, after something. Huh?
Yes, that's the activity that now we are fighting it. Certification of offset. Which is that we've already created
the government with the affidavit, because it's also what stands they could take. They also can fix the matter immediately after entering the case.
Okay, Mr. A.R. Tabilla, Senate Counsel for the
Higher
Education Department, submits that affidavit has been filed today.
Yes, received a copy today.
Has filed,
We are filing today. We are-
submits that the affidavit of the Higher Education Department will be filed today.
Okay.
And a copy has been furnished to the writ petition. You are not filing anything.
I am preparing for the AIC.
Recognize.
So, Mr. The university is not recognized by the AIC. But as per the act, the prior approval of the AICT is only required to pick up a technical course to the technical institute. If it is a university, then they can continue with the course. Approval of the AICT is only required if they want the benefits of a scheme class. But since the university, prior approval of the AICT perhaps may not be necessary for that's why the necessity of
Mr. K.P. Pathak, Learned Counsel for the AICT, submits that prior approval of the AICT is not required, is required for a college that is with-
for technical.
for technical institution and not for a university.
Because that is because prior lottery is authorized, but lottery may not record this today.
Okay, don't write this.
Lottery from the next day.
Okay, right. Mr. K.B. Pathak, Learned Counsel for the AICT will inform this court as to whether the prior approval of the AICT is necessary to the university for running the course, running the technical course run by the university.
It has been decided by the Supreme Court also. Yes. Like difference between university and technical.
But if you have the, yes. Anything to say, they don't know. Right. Mr. A.R. Bhuya, on behalf of Mr. H. Shamwa, counsel for the UGC submits that no instructions have been received by them.
UTC stand is already on record.
Anyway, huh? Not then?
Page 45. Page 45.
Okay, no, this is the matter on 23, 24,
I'll leave it to your notice.
24. Or before that. 22,
22.
22.
100. All right.
Suspension, my lord, is continuing. Even after 3 months, they have not reviewed. Now they are saying they passed a fresh. Fresh. A fresh. Rule doesn't permit them, my lord. Besides the law I have. Where is the procedure is pending? Where is the- Okay. In the law. It is shown paragraph. In accordance with Rule 10. Yes. 10. On yes, what is this? This is the rule. This is what has been decided. This was the issue in Ajay Kumar Chaudhary only.
Yes.
Yes.
My contention is that charge sheet has been issued thereafter.
10-1 AP. discuss this issue. Have you given a copy to the other side? You got this also. I don't know how this helps you.
And supported the judgment of all of us.
Yeah.
Paragraph 5. Paragraph 5. Put it. Paragraph 5. Yes, the ground given by the High Court to state the operation of the suspension order is patently wrong. There is no restriction on the authority to pass suspension order second time. The first order might be withdrawn by the authority on the ground that at stage, the evidence appearing against the employee is not sufficient for the some reasons. It is not connected with the merit of the case. And second,
So you see, straight away, the issue is the first order might be withdrawn
yes, sir.
by the authority on the ground that at the stage the evidence appearing against the delinquent employee is not sufficient or for some reason which is not connected with the merits of the.
Yes, sir.
So this is the background.
Yes, not to make
Yes.
it subsequent.
Yes.
The first order might be withdrawn by the authority on the ground that the state the evidence appearing against the delinquent employee is not sufficient or for some reason it is not connected with the merit of the case. As happened in the present case, the earlier order of suspension dated so was passed by the High Court. The ground that some other suspended officer has been allowed to join duty. The order has nothing to do with the merit of the case. Ordinarily, when there is an accusation of divulgation of money, the delinquent employee has to be kept away from the establishment till the charge are finally disposed of. Whether the charge are displaced, received or vindicated, and are trained only to keep the individual concerned out of the employment is a different matter. But even in such case, no conclusion can be arrived at without examining the entire record in question, and hence it is always advisable to allow the disciplinary proceeding to continue unhindered. So here, Lordship, what happened? Initially, he was arrested, that he was deemed to be put under suspension. Admittedly, it was not reviewed. Thereafter, charge sheet was issued, then authority think it
How
proper.
does this help you? Which part of it helps you?
Lordship, because in this case also, Lordship, the acquisition was serious.
You see, it's not that. You see, the the question of a second suspension only comes into play when the first suspension order has been withdrawn.
The Lordship may please to see our.
It's only on that state, and the withdrawal can be due to
No.
any number of reasons.
Well, Lordship, here what happened, but Ajay Chaudhary, if it is not reviewed, then it is gone.
Correct.
Yes, Lordship. Now we have after submission of
No,
charge sheet.
no. You see, but then you see, the validity of a suspension order cannot survive beyond 3 months if
It is not reviewed.
it's not only that, if there is no memo of charge or charge sheet
Not
is submitted within those 3 months. Out here, in your case, was the charge sheet or the memorandum of charge submitted within 3 months from the date
It was not
of
submitted. It was not
then
submitted.
it
It
comes,
was
then para 21 of the Ajay Chaudhary comes into play
Yes,
immediately.
after charge sheet was submitted, then he replied, then on at
Then it could not survive.
Lordship may come to page that rule 10,
Rule 10.
rule 7,
Yes,
Provide-
rule 10, 7, yes,
proviso.
yes.
Provided that no such review or of suspension shall be necessary in case of deemed suspension.
No, why are you reading review? It is an order. Please read again properly.
Yes, sir. Provided that,
Provided that, okay. Now,
Pro-
provided that,
provided that in no, that no such review or suspension shall be necessary in case of deemed suspension under sub-rule 2. And he was suspended on ground that he was arrested in case of sexual harassment to a student. Then, Lordship, if the government servant continues to be under suspension,
just a minute, an order suspension, just read the first part.
yes, sir.
You
An
cannot,
order of suspension. made-
your proviso will come only after the
Yes, yes.
first part.
Not
Okay.
correct.
An order suspension made or deemed to have been made
Under sub-rule 1
on
and
a toll shall not be valid
valid after
after a period of 90 days unless it is extended
after review.
after review for a
or
further period before the
expiry
expiry,
of 90 days.
before the expiry of 90
Yes,
days.
sir.
Next,
Next, look, provided
provided
that no such review or suspension shall be necessary in case of deemed suspension under sub-rule 2, if the government servant continues to be under suspension at the time of completion of 90 days of suspension and 90 days period of such case will count from the date of the government servant detained in custody is released from the detention or the date on
and the
which
90 days period in such case will count from the date of submission release from detention.
now Lordship, question arises here.
Is
Whether-
different. For the date on which the fact of his content is intimated to the appointing of certificate,
I have
provided that no such review of suspension shall be necessary.
in case the deemed suspension under sub-rule 2. And admittedly, he was
No such
suspended.
review shall be necessary. In the deemed suspension under sub-rule. Now, you see one thing. In your case, this is are you covered by the Assam rules or by the
No, no, because it's a.
Yeah,
but
federal government?
TCS. TCS rule itself is clear.
Show me.
That's 6, sir. In suspension and suspension method, it's
An
a
order of suspension made or deemed to have been made under this rule shall be reviewed by witness now. Before expiry of 90 days and but what about this 7, the proviso to 7, rule 7?
that is from the date of intimation.
Huh?
We have intimated, once we came out from the.
When did you come out?
We came out on 29/24.
2009,
Yes, and we have intimated on 23/9/20.
23/9, 20. And when did the thing take place? And when was the charge sheet framed?
Charge sheet
I
was
think by
given on 7/3/25. 25.
7/3/24.
25.
25. So, go,
Okay. There is no dispute with regard to review and other.
no.
My contention with the Lottie that we have authority to put him suspend under.
You cannot give a second suspension order unless there is a withdrawal.
No, Lordship, in our order, Lordship, it has been stated,
What has been stated?
last 2 lines.
Last 2
Whereas
lines.
during the
You can
second-
extend the suspension order.
Lordship,
You can, yes, last 2 lines, where? Last 2 lines,
the
where?
order superseded the earlier order.
Which, where are you reading, Mr. Council? Last 2 lines of,
Lordship for
Okay,
the
that-
suspension order.
you can say anything here, but there has to be a source of power.
No, Lordship, definitely it is before you Lordship to decide.
No, that's what I'm saying, show me. That's what I'm asking you.
This order supersedes the earlier order of deemed suspension issued by State Council.
Sorry. The deemed suspension. So you mean say one suspension for DP proceedings and one suspension order for deemed suspension?
No, Lordship, here what happened, as per Ajay Chaudhary, our earlier suspension order has become invalid.
Correct.
thereafter we to chart sheet and considering lordship may come to paragraph 10 of this chart sheet.
Yes, I've got,
Paragraph 10.
yes, yes.
We find from the chart sheet that the allegation against the first respondent are grave inasmuch as they indicate that the amounts mentioned therein are not deposited in the bank and court entries has been made in the book, in the passbook of the relevant account and the amounts are shown to have been deposited. In the circumstances, the High Court should have not interfered in the order of.
You see, this judgment was passed in 1993.
Yes, sir.
Okay, the issue, I'm fully aware and of the gravity of the case against the petitioner. It's POXO, correct?
No,
Right.
yes,
POXO, section 6.
yes, that's correct.
It's a serious offense, very serious. But then I have got to go by what the law says. And the law laid down by the Supreme Court now is paramount. And I am bound by it. That's all.
Lordship in Ajay Chaudhary, lordship.
You see, Ajay Chaudhary 21 is not here.
No, lordship, because this is the earlier judge.
Actually, this is of 1993. The
Lordship,
law has changed.
no, law has changed, but with respect to, lordship, Ajay Chaudhary has not said that department cannot issue second subsection.
No, but then I'm going to say,
Court has reviewed that whether suspension order has been reviewed as per the rule 10 of the.
I'm not going into that. This second suspension cannot be, but maybe you'll have to challenge the second suspension.
He has not said, because it is passed
Yesterday,
on 8th, day before yesterday. On 8th of April.
during this matter being sub judice.
Yeah, lordship. Yeah.
And then go. How can it? I mean, you've got no case. You cannot in the
The charge sheet
meantime.
was issued on second.
Maybe, you see, the issue that was there at the time of filing, that is to be, subsequent thing does not validate your action at all. Really, right?
Lordship, the lordship can consider my submission that we have authority to issue second subsection.
I will write everything that you want me to say.
Lordship,
That is not a problem. That's not an issue.
and rule 7.
And you also should understand, once the matter is sub judice, you cannot do as you like.
No, lordship, may please to see the order passed by this honorable court,
Right, third, Mr. We did ask learned senior counsel for the petitioner, assisted by Mr. D. Khalid. Also heard Mr. S.C. Kal, learned counsel for the Assam University. The petitioner is agreed by the respondent authorities not reinstating the petitioner in his service in view of the fact that there has been no review of the deemed suspension of the petitioner, which had been made by order dated 19/8/2024 with effect from 15/8/2024 within the statutory period of 90 days as provided in section 10, no, in rule 10 of the Central Civil Services bracket class, control and appeal bracket rules 1965, hereinafter referred to as the CCS bracket bracket CCS CCA rule. Huh? The petitioner's case is that the petitioner is an assistant professor in the Department of Law, Assam University. An FIR dated 14/8/24 was lodged against the petitioner on 14/8/2024 by a student in the Department of Law, alleging that the petitioner had tried to outrage her modesty by taking advantage of her position when she was alone in the petitioner's chamber at around 4:30 p.m. The FIR submitted by the petition, by the student was registered as Dwarbond PS case number 24/2024 under section 74/75 bracket 1 bracket Roman 1 small /75 bracket 1 bracket Roman 2 small Bharatiya Nagarik Suraksha. This is BNS. Yes. And subsequently, the petitioner was arrested on 15/8/24 in connection with the police case. Next part. Pursuant to the arrest of the petitioner on 15/8/2024, the respondent number 2 placed the petitioner under suspension with effect from 15/8/2024 by order dated 19/8/2024. Next part. The petitioner was granted bail in the police case on 20/09/2024 and he submitted a representation on 23/9/2024 intimating the authorities of his release from jail. Next part. The petitioner's counsel submit that in terms of the judgment of the Supreme Court in the case of Ajay Kumar Chaudhary versus Union of India and others, reported in 2015, 7 SCC 291. Yeah, 291. The validity of a suspension order cannot survive beyond 3 months. Beyond 90 days. Beyond 90 days. Unless a charge sheet / memorandum of charge is submitted and a review for extension of the suspension period has been undertaken. Next part. The petitioner's counsel submits that the petitioner, having been released on bail on 20/09/2024 and having intimated the authorities regarding his release on 23/9/2024, it was incumbent on the part of the respondent to have submitted a charge sheet or a memorandum of charge prior to the expiry of 90 days with effect from 23/9/2024. Prior to 90 days, what am I said? I think looking at other things. Yes. That is 22, 10, 11, 12. 10, 11, 12. 22/12/2020. However, in the present case, the respondents have the police had submitted the charge sheet only on The department, the respondents had issued a charge sheet,
7/3/25.
17/3,
7/3.
7/3,
25.
way past bedtime.
That is right.
Okay, anyway. 7/3/2020. And no review of the suspension order had taken. He submit that by taking into by applying para 21 of the judgment of the Supreme Court in by applying the para 21 of Ajay Kumar Chaudhary Chupra, the petitioner suspension order ceased to exist, could not have existed, um, could not have remained in existence beyond 22/12/2020. As such, the suspension of the petitioner by the impugned order dated 19/8/2024 should be set aside and the petitioner should be released on bail. The petitioner should be reinstated into service. Reinstated into service. Full stop. Correct. Huh? No, that is only your submission.
Yes.
I am and now I'm going to record his submission. Then my part will come out. Mr. S.C.K.R., Learned Counsel for the Assam University, submits that though the factual aspects of the case is not denied by him, he does not, he is not in agreement with the submission of the petitioner's counsel that the suspension order, that the petitioner would have to be reinstated into service in terms of the judgment of the Supreme Court in Ajay Kumar Chaudhary Supra, inasmuch as a fresh suspension order had been issued to the petitioner on on 8/4/2025 on the basis of a review no review. No, on basis of fresh suspension order dated 8/4/2025, which had been made in pursuance to the resolution passed in item number 3 in the 174th meeting of the Executive Council of the Assam University on 13/3/2025. 13/3/25. Next. He submits that in terms of the proviso to Rule 7 of the CCA rule, the no review of the suspension order of a government servant who is under deemed suspension is required to be made. Within 90 days. Correct? That's all. He also submits that in terms of the judgment of the Supreme Court, in the case of UP so very long name, huh? Versus so reported in 1993 supply 3 SC 483. A fresh suspension order can be issued by the authority. That's all. Next, he accordingly submits that as a fresh suspension order has been issued to the petitioner by order of suspension dated 8/4/2025. The same. The suspension of the petitioner cannot be revoked, should not be revoked, and the petitioner should not be reinstated into service. I have heard the learned counsel for the party. Give me Ajay Kumar Chaudhary, everybody. In the case of Ajay Kumar Chaudhary Chopra, the Supreme Court has held at para 21 as follows. Hmm. Next. As can be seen from the law laid down by the Supreme Court, where is that? We don't have. That's para 21 only. Nothing, I don't want to. No, it will be better. He'll help it. And the whole of para 21 not required. Kalpana, just a few 5-6 lines. Okay. So, the next para. Rule 10, bracket 1 and 2 and 2, comma, rules 10, bracket 1, 2, comma, bracket 6, bracket 7 of the CCR rule takes as follows. So this portion only is required. So come back to the para. States as follows. Is a perusal of the above clearly shows that the currency of a suspension order cannot extend beyond 3 months unless within this period a memorandum of charge, that charge sheet, is served on the delinquent officer / employee. Full stop. If the memorandum of charge / charge sheet is served, a reasoned order must be passed for the extension of the suspension. There is a review portion.
judgment or
I said that review is, I think, in the administrative, in the Assam case.
in the,
It's not with regard to this year.
no, in CCS.
In this year, it's not there.
Is not.
So we have got to say, we have got to differentiate. In, that review is not required here.
Not required. In Assam discipline.
That, in that, Assam, this is, no, yeah, yeah.
Always cases there, it says
Ah.
it is same one and the same.
But then out there, review is required.
In, yes, in Assam.
In that Assam case, review is, out here is not.
The rule is different.
Correct. Whatever, that's all, Next. So we'll change whatever. We get slightly confused, no, sometimes.
Yeah.
Next. Then after this, that, that section 10, 1, 2, 6, and 7, okay? Next para, a reading of section 6 of rule 10, a reading of subsection, sub rule 6 of rule 10 of the CCS CCA rule provides that an order of suspension made or deemed to have been made under rule 10 bracket 6 shall be reviewed by the authority which is competent to modify or revoke the suspension before expiry of 90 days from the effective date of suspension. And pass orders either extending or revoking the suspension. Subsequent review shall be made before expiry of the extended period of suspension. Extension of suspension shall not be for a period exceeding 180 days at a time. Next part. Rule 10 bracket 7 of the CCS CCS rule. CCS CCA rule provides that a deemed order of suspension shall not be valid after a period of 90 days unless it is extended after review for a further period before the expiry of 90 days. The proviso to section 10 bracket 7 provides that there shall be no review of a suspension. It provides that it shall not be necessary for review of suspension in the case of deemed suspension if the government servant continues to be under suspension at the time of completion of 90 days of suspension. And the 90 days period in such case will count from the date of government servant who is detained in custody is released from detention or from the date on which the fact of his release from detention is intimated to his appointing authority. Full stop. Next part. The import of the proviso to clause 10 bracket 7 of the CCS CCA rule clearly shows that the that though there's no requirement for review of a suspension of a government servant who is in custody within 90 days, comma, a review of the suspension order is required to be made within 90 days from intimation of the date of his release from jail to the authority. Next one. Isn't that correct? That's correct. Next. I just wanted to know if we're on the same page, because I'll have to then explain more. Next. In
Intimation was made on
correct.
29.
Next para. In the present case, the petitioner was released on 20/09/2024, and the fact of his release was intimated on 23/9/2024. As such, a review of the deemed suspension had to be made by the authority within 90 days from 23/9/2024, which would end on 22/12/2024. As the petitioner's deemed suspension order dated 19/8/2024 had not been reviewed within the 90 days period, the petitioner's continued suspension beyond 23/12/2024 was illegal, was not proper. Puspa. Next para. The above being said, the Council for the Assam University has taken a stand that a fresh suspension order can always be issued beyond 90 days of the earlier suspension order. And as the suspension order of suspension dated 8/4/2025 has been issued. No, cut that. With regard to the other aspect, with regard to whether the order of suspension dated 8/4/2025 would be a valid suspension order. This court finds that the same has been issued during the pendency of this writ petition. So, the writ petition has been filed on 5/3/2025, and this court on 10/3/2025 had issued notice to the respondents, which had been accepted by the counsel for the respondents on 10/3/2025 itself. Interestingly, while the issue of whether the deemed suspension order dated 19/8/2024 could be said to be valid was being decided, the respondents have 1 month later issued the order of suspension dated 8/4/2025. So whether an order, you can change the game during the during a matter being sub judice. That's the issue. I'll have to look into it. And if I find that this is not proper, I might have to issue call for some proceedings against the officials. And I'll look into that. Next.
Activity council.
I don't know what, that executive council. That was 10th March.
Yes.
This is 5th March.
Yes, 70. Yes, sir.
And 10th March is the day you took notice.
Yes, sir. That's happening here, not hide anything.
Okay, right. In the case of, uh, so and so, very long. Supra. The Supreme Court had held no, in the case of census, it is seen that the Supreme Court had held that there was no restriction on the authority to pass a suspension order a second time. To stop. However, it also observed that the first order of suspension might be withdrawn by the authority on the ground that at that stage, the evidence appearing against the delinquent employee was not sufficient, or for some reason, it was not connected with the merits of the case. This does not say much. What does it basically say?
Okay, for in paragraph 5, last 7 lines are of the theory. Paragraph 5, start from where it stated earlier. Stated earlier. It has been specified the order of suspension on the ground of that the authority has the power to pass the second order of suspension in the same case. We are afraid that the High Court has substituted the nature and purpose of the power of suspension in the management. It's not disputed that the second all the officers concerned are charged with the charge sheet have been suspended.
Have you got this order?
No.
Yes. Yes.
This 93 judgment.
Yes.
Not applicable in this case because George Chaudhary is not, but the rule also not this one.
Nothing, correct.
It is earlier judgment, not.
Maybe.
Earlier judgment on this. So there is no question of you considering the. I'm just pointing out another judgment, the legal order is right. Where legal order, but I'm not put it because under this is concerning upon. It says that both same substantial, they, that's it. That the other judges. Laboratory.
No, that's what even I've held somewhere.
Yes, you also have there one judgment, so I have annexed with the repetition feature. Page 41. No dispute with regard to a position held by the adjudicator. Proposition and even the rule 6, sub rule 6 of.
This order, this judgment of the,
Is basically not clear what happened.
it has not made any elaborate discussion, nothing. In it. Just basically said that they can file a separate suspension order.
The effect of this case is that earlier a suspension order was passed, that was satisfied by Honorable High Court. But the ground that that there is no power to issue second suspension. Then matter went to Supreme Court says that no, it's the priority of that authority to put him under suspension and when charges is being filed, the seriousness of the charges to be looked. That is the provision of this. What is purpose I have explained for.
But that is not the issue. But
Here, what happened?
in Ajay Kumar Chaudhary, it's not the issue whether charges are serious or not serious.
No, not serious.
How can you differentiate? If a person steals 1 rupee and 1 lakh, it doesn't make a difference.
No, here the seriousness of the charges to be because.
That is what I'm saying. Can you be correct? Supposing a person steals 1 lakh rupees and a person steals 1 crore, so that 1 crore has to be dealt more sternly than 1 lakh.
Justify not make comment.
No, just I'm asking you. I'm not. You see, it's a dialogue.
No, definitely.
You cannot say that I will not answer. You have got to answer because we have got to get to the bottom of it.
Because here.
So I'm trying to understand an issue because there's so many ways of looking at things. It's like being there's a saying that if you steal a little, they put you in jail. If you steal a lot, they make you king.
We cannot.
There are some things out there.
In paragraph
Some
10,
people.
that is been explained by the Supreme Court.
Huh?
Supreme Court, they can know of this fact in paragraph 10.
Paragraph 10.
Although amount has not been mentioned, but how.
That is not the issue.
Yes.
Why are you going
No, no,
into
that
that
is-
issue? That's
that
not
is
the
not the
issue.
issue.
The issue is not whether it's a serious case or not.
No, Lord, see, Ajay Chaudhary has not taken into.
That is what, and that cannot be an issue whether a case is serious or not. The law is the same. Whether the offense is, whether he has stolen 1 rupee
In Ajay,
or 1 lakh, he is still a thief. You cannot say that a person who steals 1 rupee is not a thief, but a person
No,
who steals 1,000 rupees is a thief. There's no benchmark.
it is not my commission at all. Lord.
Yes.
But in
So
Ajay
that is what. So this decision
Yes,
is to that effect.
no, this decision says that the authority has the power to issue second suspension.
Under what provision of law?
No, nothing has been discussed.
That is what.
Here, the proposition is held by what I have understood from reading of the judgment. That the authority has power.
It has not gone into the detail of Rule 10 of the
No.
CCA rule.
That is not there.
Correct. Ajay Kumar Chaudhary is gone now. So,
Ajay Chaudhary says that.
okay. Anyway, what have I said? Super. Next step. The no, continue. The Supreme Court insolence to Supra has only stated that there is no restriction on the authority to pass a suspension order. A second. Next step. This court, on perusing the judgment of the Supreme Court in 1993, in Penso Supra, finds that there is no discussion made with regard to Rule 10 of the CCS. However, the decision of the Supreme Court in Ajay Kumar Chaudhary has gone into a detailed discussion on before that. It has only gone into the issue of whether the allegations made against the delinquent officer therein was grave or not, and had come to a finding that the allegations were grave. In the case of Ajay Kumar Chaudhary Supra, the Supreme Court had gone into a detailed discussion into the provision of Rule 10 of the PCSCCL and had not delved into whether the whether a second a second suspension order could be issued only because the charge against the delinquent officer was grave in nature. Next part. It had basically laid down the law that the currency of a suspension order could not extend beyond 3 months if within the period of 3 months the memorandum of charge sheet had not been served on the delinquent officer / employee. As stated above, the petitioner had not been served with the charge sheet. Had been served with a charge sheet on only after he was jailed when 29, no, he was arrested when 15, 8, 24. 130 after 4.5 months after his no, not for half 7-3, no? after 7 months, (23 days) after his date of arrest, and and 5 months, 15 days after he had intimated the authorities of his release from jail. In terms of on considering the judgment of the Supreme Court in Ajay Kumar Supra, and the fact that no review has been undertaken by the respondents even till today with respect to his earlier suspension order dated 19/8/2024, comma, the earlier suspension order cannot to, could not have been could not have been extended, could not have been, the earlier suspension order could not have been allowed to operate beyond the set period, beyond 22/12/2024. As in as much as the same, in as much as the validity of the same had expired on that. Keeping in view the but what to do? Should you challenge this? Stepping aside. In the midst of this argument under the case, they have brought this. It's not meet the what they ask the question. It has to be accepted. Keeping in view the fact that consequential order. Keeping in view the fact that the and the validity of the suspension order dated 19/8/2024 had expired on from 23/12/2020. In the absence of any charge sheet being filed within prior to 23/12/2024, and no review being undertaken by the respondent authority. The said suspension order dated 19/8/2024 is set aside. Full stop. Full stop. As the order of suspension dated 8/4/2025 has been issued during the pendency of this case. Come on. This court is of the view that no action should have been taken by the respondent during the case being sub judice, during the issue of whether the petitioner should be reinstated was being decided by this court. This court accordingly is of the view that in terms of the judgment of the Supreme Court in Ajay Kumar Chaudhary Supra, and in view of Order 10 Rule 10, bracket 6, of the CCA rule, the order of suspension dated 8/4/2025 cannot survive. Cannot be allowed to continue. The same is also accordingly set aside. The respondents are directed to reinstate the petitioner. However, keeping into the facts of the case, the respondents are given the liberty to transfer the petition to any other college,
Campus is there. The campus is
to any other campus,
campus.
to any other campus of the university.
The lordship will mention about the proceeding to be. We can do it another one.
Why should there be direction from this book?
They will.
It is,
Period of,
huh?
in a period of.
There is a criminal case or a thing? There's a.
Criminal case is there, now we have to start it.
Okay, we should touch.
It's in proceeding in the.
Okay, just you write one thing in the Mr. KCSCKL submit that disciplinary proceedings has also been initiated against the petition.
In criminal case, it has been stated. That's what it. It is
Okay.
independent to the criminal.
That's independent. You can do anything. No, just write at the bottom, you write. It is hoped and expected that the disciplinary proceeding initiated against the petitioner is taken to its logical end expeditiously as possible.
So reinstatement within a particular date.
Okay, the reinstatement of the petition should be done within a period of 1 week.
2 weeks.
2 weeks from the date of receipt of a certified copy of the report. Page 76, 77. So you can put it with the phone also. Yes, next.
Please, your lordship. The petitioner has not received arrear and current salary matter till date.
Huh?
Petitioner has not received any arrear and current salary till date now. So now we go to direct.
Yes.
Regarding, he has joined, my lord. Regarding, he has salary proposal, my lord. Right.
Concurrence on the proposal for creation of supernumerary post returned. The file has been returned.
There, now, the news of the judicial department.
This is a contempt case.
Yes, yes.
This is, you're not playing around. It has been returned by the finance minister. Are you party here? Huh? Where is the order of the court?
28 to 2025.
Where is the page? Where is the order? Contempt has been,
Page, my lord.
where contempt has been alleged.
8, my lord.
Huh?
Page 8, my lord.
Page eight.
Fighting para, my lord.
Huh?
Page 10, my lord. Para 4.
I think this is just playing around. Look at.
As per Procedural, we have submitted the final finance department for process. Now they have written with some query.
Where is the letter sent by the? Where is the query?
File number is there, madam. However, finance FA department returned the file by PSE number so and so dated 13/3/2025 requesting to resubmit the file with the following: duly authenticated checklist for creation of supernumerary post, the views of
I think what you can do is file a fresh petition, putting all of them parties, all the departments required. We tell them to do it within 1 month and then contempt against all of them. Otherwise, it becomes difficult. Or maybe he's not taking up. I don't know why he wants the views of the now finance department is doing this. They want the views of the judicial department. Right.
is that the extra verification for information for the record or
This order has been passed in 2016.
the proposal for that that is why the delay is the duty of the department to query it and find out why that
Right, right.
My lord, finance department already approved the supplementary demand of
Huh?
rupees. The finance department already had approved the supplementary demand of rupees 3 my lord, 24,82,000.
Where is that?
My lord, as per order, honorable court order, this is 28/2/2025 in contempt case, my lord. Where a letter has been quoted, my lord.
Ah,
Letter dated, my lord, 8/1/2025, my lord, para 4,
ah.
page 3, my lord. Second paragraph, my lord, finance budget department has approved the supplementary demand of rupees 24,82,000 for payment of arrears salary under the so and so during the financial year 24-25.
The letter has not been made part of the record. Okay, right. Mr. R. Katanis, Senate Counsel for the petition, has submitted a letter dated 9/4/2025 issued by the Joint Secretary of the Government of the Assam Department of Food Education, which states that a proposal for creation of supernumerary post for the petition was moved to the Finance Department by file PS P/S number E-628-541 dated 13/3/2025. No. That number is kept separate. However, the file was returned by PS number 7, requesting the Joint Secretary to the Government of the Department of Food Education to resubmit the file with the following. Number 1, duly authenticated checklist for creation of supernumerary. Number 2, the views of the Judicial Department. It also states that the file 447079 was endorsed to the Judicial Department for views on 13/3/2025, which is still under process at the judicial. Next paragraph. Mr. N.J. Katani shall obtain instructions as to whether as to why the judicial department has not given its views till date. Further, he shall also obtain instructions with regard to the letter number E-447079-75 dated 27/2/2025, issued by the Joint Secretary to the Government of Assam, Department of School Education, which reflects the fact that the Finance Bracket Budget Department has approved the supplementary demand of rupees 24.82 lakh for payment of arrears salary in this proposal of 24,81,700 for payment of arrears salary for the petition. List the matter on this month only. Give it this month. We are going to monitor it very closely. 20.
Regarding.
The respondents challenge. Sure. No. Why don't you give current salary also? Mr. N.J. Katanel have also informed this court as to why the petitioner's current salary is not being paid. You have been paid till when?
2011 February.
The arrear salary, that current salary. When did you get your last salary?
February 2011.
No, cut that. Last. Huh? Okay, then after that.
Wait, Vijay. As per the petition, the petitioner has submitted their
NPS.
admitted to the respective colleges, Your Lord.
So now, yes, who is for the other side?
I hope,
Mr. Agarwal. Who is Mr. Agarwal? Who is Mr. Agarwal?
no, I'm for K. Gogol Lottery, we have 1, 2, 4, 5 Lottery. But one instruction I have lost.
Huh?
One instruction I have lost. Regarding this NPS, that the college authority almost everything submitted to the department. Some colleges left.
Okay.
That's just present status.
No, but more than that, what about the area salary?
So because of that area, so
That NPS,
Yes.
so they have said that they have submitted everything.
then
All the petitioners have
no, I have call the office of that the college authority almost all the college authorities some of the college doesn't submit. It's just a people.
We are not worried about
No,
the
no,
other colleges. We are only worried
Yes,
about the
okay.
petitioners here.
But after vacation, after please, then in the
You are appearing for whom?
I am for 1, 2, 4 and 5, and on behalf of K. Gogol. The contempt.
1, 2, 4, and 5.
Lord, I am on behalf of K. Gogol. I am not in state law.
So,
After vacation, please.
so you have received the NPS form.
From some of the colleges have still not subject. Some of the colleges. That's the present instruction I have from the office.
Mr. Counsel, we are not bothered about
No,
some
that's
of the
the law.
colleges.
I
We are
understand.
only bothered about this.
Look, I understand. It's a whole matter. Look, I understand.
You understand, but then if your clients don't understand, we'll
No.
call them.
No, nothing. After vacation, nothing. All the college authority, some of the college authority has not placed that. Then in
How many petitioners are here?
23, 24.
Different colleges.
the
Yes, different colleges.
Right.
almost
Mr.
as we are on behalf
S.
of
Buya on
on
behalf of
behalf of
Mr. K. Gogoi,
for 1, 2,
appearing for the respondents number 1, 2,
4 and 5.
4, and 5. Submits that all the colleges have not submitted the undertaking made by the petitioner for grant of NPS, to enable the authorities to process the payment of arrears salary to the petitioner. He submits that as and when all the colleges submit the NPS undertaking, the process would be completed shortly. On the other hand, Ms.
And so forth.
M. Zomonpu, Learned Counsel for the petitioner submits that all the petitioners have submitted their undertaking for grant of NPS and have submitted the same to
To
the-
the respective.
the respective college authority. Leaves the matter on this month, end of this month. To enable enable the respondents to give the status of the area salary claim made by the petitioner. Yes,
But yesterday, I could move the relay code to the
okay.
the notice has finished. I have the order.
So we'll wait.
But what has happened, I have checked it, but they have filed this data bill against the date person.
Against the dead person.
Because this interlocutory application as well as data bill cannot be filed against the date person.
It's only against one person.
Okay. Number
That information
How many dead persons are here? IA. Who is the dead person? Which one is the dead person?
The petitioner number 2.
Is the dead person?
Yes.
Lal Chand Ali.
Yes.
What about the number one is still alive?
Number one is
Then-
still-
then
I have implemented substituted the phone number 2, the petitioner number 2. And more or less, simply filing this case, will take time after 5 years. And the one person has expired and others 2, 3 is going to be retired. Without any stay order.
there is
that is there
Cannot
also.
because now they have to file an substitution petition. In the mixed case as well as in the reader petition.
So you will be appearing in the division bench. Correct.
Yes, sir, that follows.
You expedite it. You expedite it.
if he appears, I can give him a copy. Have a copy of
I take instruction from them.
Okay, right.
More or less,
Mr.
5
N.J.
years already
Khatania,
there.
Learned Counsel, appearing for the respondent, submits that appeals filed by the
Appeal not
State
yet
of
numbered,
Assam.
madam. Appeal not yet numbered.
no, submits that the application for condonation, that is IA Civil 1134 of 2025 and 1139 of 2025 were listed before the court on 9/4/2025 and notice was issued. The case is to be listed after 4 weeks. He accordingly submits that he needs some more time. This is the matter. After 4 weeks. In the meantime, you file your thing to have
Well, after 4 weeks, the date may be given in the.
give a date.
Yes, well, I will take instruction and file.
Yes.
Apply. Oh.
Maybe I did cookie.
In this matter, I have received one instruction here, madam, and as per that instruction, madam, government has to place the matter to the finance department.
Okay, right. Mr. U. Sharma, Learned Counsel for the respondent, has submitted letter dated 10/4/25 issued by the Deputy Secretary to the Government of Assam Department of School Education, which is to the effect that the matter regarding the proposal for waiver of the excess amount paid to the petitioner has to be endorsed to the Finance Department for their decision. Will be endorsed, will be. He says that will be endorsed to the Finance Department. To the Finance Department for their decision. This is the matter on. This is the matter on, give a date. On which date? The Mr. U. Sharma shall produce the letter issued by the Secretariat of the School Education Department endorsing the proposal for waiver of the excess amount paid to the petitioner, to the final department. This is the matter on 30th.